Good evening and welcome to everyone. And when we have Mr. P.S. Rajagopal, a senior advocate, two things are bound to be there, that it will be full of knowledge. And secondly, the topic will be such fascinating that everybody will be pleased that he is enriched with knowledge. When he shared with us that we can discuss about the difference between previous approval and sanction under the Prevention of Corruption Act 1988, we discussed amongst ourselves at the first brush, it would seem that probably they are synonyms and there will not be much difference. But that's the today's session where we move forward and learn the differences between the two. I will not take much time and I will request Sir to share his knowledge on this interesting and a fascinating subject. Over to you, sir.
Friends, Vikas and friends, it has been a long time I have been with you. And when Vikas asked that I should speak something about criminal law, I thought the best thing would be to speak on difference between previous approval under Section 17 capital A of the Prevention of Corruption Act and post-investigation sanction for prosecution under Section 19 of the Prevention of Corruption Act. Because 17 capital A has come into effect in the year 2018, though several efforts were made in the past to introduce a mechanism of previous approval of the competent authority to the requirement of previous approval by the sanctioning authority in matters covering exercise of discretion. After 1960, or even slightly earlier to that, the governments have entered multifarious fields, either as government itself or as public undertakings or corporations or statutory bodies. Most of the decision making in the government earlier was confined to awarding of contract for improvement of roads or making of the roads. Even the major irrigation projects were rare. But from late 1950s, the scenario changed. Even the government itself floated huge irrigation projects which involved decision making more frequently and more, I would say, value-based or judgment-based in conducting business of the government and governmental agencies. What does a decision making involve in any enterprise or the government? The decision maker has several choices. Say, take the simple case of price fixation, which is now very topic of the day regarding that excise policy of the Delhi government and so many policies of so many state governments have ran into problems. What is the principal allegations there? Principal allegation is the ultimate choice made by the decision maker was vitiated by corrupt motive. Now look at this. Any exercise of discretion would involve making a choice. For example, in awarding tenders, of course, Vigilance Manual says award to L1. But there are cases and cases where lowest bidder may not be awarded the contract for various reasons, such as very unreliable record, past record, or rates being so abysmally low in respect of certain items, it may not be workable. Then past record of the bidder about arbitration claims, then abandoning the projects and all that. Several issues would go into decision making. Every decision making involves making of a choice. The choice should be informed choice. The case started building up from the case worker. Of course, there is a joke in the governmental levels that ultimately what case worker writes is approved by the minister. I don't subscribe to that, because case worker writes and then everybody puts yes, yes, yes and all that. And if there is some controversial thing in that, they say, please discuss, and then they say yes. That is not the reality, though it may look so. Really, the case worker places all the facts and forwards the file to the next higher authority. Then maybe at a slightly, at the secretary level, if the decision is to be taken by the minister, or at the deputy secretary level, if ultimately decision making is at the level of the secretary to the government, they start writing, these are the choices available. 1, 2, 3. Then discussion on pros and cons of each of the choices will be recorded there. Then the matter goes to the joint secretary. Joint secretary says, A may be approved. Then secretary, if he differs with that, he would say, A has these inbuilt inadequacies or problem areas, therefore B may be approved. And ultimately, minister says what can be approved, and whatever he wants to approve, he would approve. This is a normal process of decision making. In most of the cases, starting from case worker up to the decision maker, there would be unanimity. In some cases, there could be divergence also. What was happening, as it happened in, say, the 2G price fixation case? Forget about the modalities. Auditor says, if another method had been followed, this would have been the likely gain to the government. By the choice made by the government, this is the theoretical loss that has occurred to the government. My respectful submission is, in hindsight, if you say choice A was better than choice B, but by choosing choice B, the government has incurred loss, that cannot amount to criminality unless the decision making itself shows that decision was made either based on extraneous considerations or irrelevant considerations, or a note of caution indicated by one of the participants in the decision making were totally ignored without adequate reasons, or sometimes like a halo. You may not be able to pinpoint what has gone wrong at a particular stage or at which stage. But if you read the entire file, it is not difficult for you to gather what I should say, a perception that something is wrong. A halo of dishonesty or recklessness or decision having been taken for extraneous considerations could be there. But most of the cases, choice may be wrong, but decision would have been honest. Now, if you leave it to the hands of the police or, say, auditors, anything not in accordance with the rule is a wrong decision according to the auditor. Any wrong decision is a crime according to the police. Therefore, the fate of the public servants was always left either in the hands of the auditors, who are theoreticians, and who look at the thing after the event, or police, who are normally used to investigate crimes under the IPC, like assault, attempt to murder, trespass. These are things where no application of mind is required to commence an investigation. Somebody has been beaten, start. Somebody's house has been broken, start an investigation. It is not a difficult thing. But when police have to initiate action in respect of a decision made by a decision maker in exercise of discretion, more often than not, the materials or the intellectual training that the police would have as investigators or auditor would have as a fault finder would be inadequate even to make the mind whether this exercise of discretion is somewhat cloudy or what I can say, shady or something that is not beyond reproach. But a complaint is made to the CBI or a complaint is made to the Vigilance Department of the state government, and the FIRs are mechanically lodged. Having all these in mind, it was in the year 1972 or 73 that in P. Sirajuddin's case, Supreme Court said that when you are filing an FIR, please think of one devastating effect that it would have on public servant. Filing of the FIR will appear in the newspaper that police, the anti-corruption wing of the state, has started investigation. The FIR has been registered against so. That one news item is sufficient to mar the reputation of the public servant, built over decades assiduously, and that news item itself can mar the future of that public servant. Therefore, in Sirajuddin, Supreme Court said that while filing FIRs in respect of cases involving decision making, please conduct a preliminary inquiry as to whether there is a possibility of there being a criminal. Don't file FIRs mechanically, and don't mar the public servants. And over a period of time, what happened was filing of FIRs even in cases where there is no criminality involved, only because the complainant or the investigating police felt that a wrong decision has been taken. It became rampant. In fact, Vigilance Commission, Central Vigilance Commission, which itself had initiated various preventive steps and was also monitoring the investigation into cases of corruption by public servants. It also started feeling that a time has come when there has to be a modality worked out where every wrong decision does not become a criminal case. Therefore, various steps were taken. In fact, several advisories were issued with the Central Vigilance Commission. But as a law, there was no way to ensure that the police do not start an investigation merely because some complaint is there or merely because the things do not look very shining. There may be something shady. Then an effort was made by the central government by issuing what came to be known as a single point directive. What the single point directive said in the government level, if the CBI wants to commence an investigation against an official of joint secretary or higher level, and then comparable levels in public undertakings, prior permission of the government or the sanctioning authority is required. The flaw in this was under Section 3 and Section 4 of the Delhi Special Police Establishment Act, under which the CBI has been established, it gave powers to the absolute powers to the police to investigate. Neither government nor the court has any role to play insofar as the investigation is concerned. It is the exclusive domain of the jurisdictional police. The second flaw in that was that it sought to distinguish the public servants on the basis of rank they hold. Ultimately, this single directive came into question before a constitution bench in Vineet Narayan, that was in the year 1998. Supreme Court did not examine whether it is discriminatory to restrict the single directive to a particular level of public service. It simply said that, look, the act, under the Delhi Special Police Establishment Act, sections 3 and 4, the investigative power is exclusively with the CBI. By this single direct point directive, the investigation itself becomes subject matter of control by the government. Therefore, this directive is bad. Thus, what was said in Sirajuddin in 1973, by then already the single point directive in some form or the other existed right from 1969. After several amendments, when the matter reached Supreme Court in Vineet Narayan, that was struck down. Principally on the ground that a statutory power cannot be encroached upon by a non-statutory instrument. Question of discrimination was not examined, if I remember correct. Then to cure the defect, the legislature introduced Section 6 capital A into the Delhi Special Police Establishment Act. Of course, in the Criminal Procedure Code, if any state government wanted to incorporate a analogous provision, that being in the concurrent list, states were free to make amendments, but not many states ventured into such amendments. What that Section 6 capital A said was that same thing, more or less what had been said in the single point directive. That without the permission of the competent authority or appropriate government, no investigation shall be commenced into cases involving joint secretary and above or appropriate levels of the public undertakings. What they called was decision makers. If you want to initiate any criminal proceedings against them by filing an FIR or commencing an investigation, permission of the appropriate government is required. This also fell foul of law that was in Subramania Swamy in the year 1990. That was in Subramania Swamy came in 2014. Prior to that, there were lot of criticism both against pre-investigation protection and also in favor of pre-investigation protection. In favor of pre-investigation protection, what was observed was the fear of CBI and the fear of the vigilance inquiries has virtually made the civil servants to so rule bound that they are not willing to take decisions, because a wrong decision can lead you into CBI trap. Not taking a decision is not viewed as a criminal misconduct. And in fact, the practical experience is that public servants who make more decisions, they are like prone to commit more mistakes, and they may end up in career retardation because of unmerited proceedings. Whereas a civil servant who dots the I's and crosses the T's, he never commits any mistakes. He will be within the bounds of the rules, and he progresses in his career also. This anomalous situation where taking a decision was a premium and taking a decision was a risk, was corroding the efficiency of the organization and the governmental setup itself. Then Administrative Reforms Commission headed by Mr. Veerap Moily also very strongly aired the view that there is a need to incentivize decision making in the government. Now, if our economy has to grow, if we have to progress, what is required is a dynamic decision making with the assurance that bona fide decisions, even if they are wrong, will be protected. Of course, bona fide error of judgment has never been a criminal misconduct. But if FIRs are allowed to be lodged recklessly, mechanically, ultimately for the civil servant to prove that he has acted bona fide and it is a bona fide error of judgment, it would take ages by when the damage to his career would have been done. The Veerap Moily's Administrative Reforms Commission also came strongly in favor of protecting honest decision-making public servants, not only in the government, but at whoever is a public servant. Finally, in the year 2013, a bill was introduced in Rajya Sabha providing for this pre-investigation protection. Ultimately, of course, several things happened: joint committees, select committees, standing committee, several committees examined of the parliament, and ultimately the act came in the year 2018. Now, what does that act says? Where there is a complaint in the matter of exercise of discretion by a public servant, irrespective of the level, the investigating police will require previous approval of the authority competent to dismiss that civil servant or public servant from service. This is the pre-investigation prior approval of the competent authority to commence investigation. This provision itself is new. It is less than 7 years old. And case law is sparse. Then at the same time, after the investigation, sanction for prosecution under Section 19 is also there. Today, an honest civil servant has two-stage protection. First stage is previous approval to commence the investigation. Second stage is after the investigation, on the basis of the entire evidence that is collected during the investigation, the authority competent to dismiss the civil servant, public servant, will have to grant sanction to prosecute. One case relating to judiciary, I can tell. Insofar as the members of the higher judiciary, that is High Court judges and Supreme Court judges, are concerned, the Supreme Court, by a constitutional bench judgment, in an effort to protect independence of the judiciary, in judgment rendered in the year 1991, in respect of K. Veeraswamy, who was Chief Justice of the Madras High Court, laid down that for commencing an investigation by lodging an FIR against High Court judge or Supreme Court judge, previous permission of Chief Justice of India is required. This law was laid down ostensibly to protect the independence of the judiciary as a response to an argument on behalf of Veeraswamy that, look, before in the court, the largest single litigant is government, and a judge has to decide every case before him without fear or favor, and most of the judgments will be against the government. The government should not be in a position to use Prevention of Corruption Act as a tool to make the judges toe the line of the government. Because one thing is very clear, at least for the last 50 years or slightly more, whether it is CBI or whether it is State Vigilance Department or whether it is Lokayukta. I don't want to say much on Lokpal because Lokpal's record is yet to be developed in sufficient numbers. Of course, there is already a record. One thing that can be said about all these investigating agencies, notwithstanding the label, is that more often than not, they will be caged parrots, irrespective of the party in power. Key of the cage will be with the ruling party. Therefore, to allay the apprehension that government can or executive can misuse the provisions of Prevention of Corruption Act to make a judge toe the line by initiating proceedings under the Prevention of Corruption Act, Supreme Court in K. Veeraswamy, a constitution bench, it said that to allay these fears, we lay down that insofar as initiation of investigation or inquiry against any judge of a High Court or Supreme Court, prior permission of Chief Justice of India is required. That was in the year 1991. But of course, the same judiciary said that you cannot bring this single point directive by way of executive instructions when it came to public servants other than the higher judiciary judges. Ultimately, it came in the year 2018 by way of law, by 2017 capital E. Therefore, let us clearly understand, Section 17 capital A is prior approval of the competent authority is required, either to commence an investigation by lodging an FIR or even to conduct a preliminary inquiry as a prelude to registration of FIR. Now the question is, what is the difference between why this two-stage? Why this two-stage? I think I have covered, saying that one is filing of the FIR itself can work great irreparable harm in most of the cases, as said by the Supreme Court in Sirajuddin. And subsequently, this was mentioned by the Supreme Court even in Bhajanlal's case. In Bhajanlal's case, before laying down 6 steps as to when an FIR could be passed, it also referred to Sirajuddin and said that in these matters, it is better to hold a preliminary inquiry before lodging of an FIR. Then again, in Lata Kumari's case, Supreme Court said it is better you have a preliminary inquiry in cases involving Prevention of Corruption Act. Of course, there is always an exception. Exception is trap case, where no prior permission is required because trap always involves an element of surprise. And you can, element of surprise and essentiality of speed, both would be compromised if prior approval is sought, or the matters are so clear in such case, prior approval will not be of much significance. Therefore, prior approval is not insisted. Now, prior approval is a pre-FIR stage or pre-preliminary inquiry stage. At that stage, what are the things that will have to be looked into by the sanctioning? First test is always whether the allegations made in the complaint, taken at their face value, if remained taken at their face value, make out the ingredients of the offense. That is the first thing. Second is, the government has the advantage of files leading to the decision and files post-decision, both of them with it. This is a material which investigating police and the complainant may not have. But the government is in possession of all these materials. In addition to applying the usual test that is applied while quashing of an FIR under Section 482 of the CRPC and 500 something in the new code, 500 and odd is something is there. The first test that is applied is whether whether the complaint contains ingredients of the offense alleged. Second is, most of these administrative matters or decision-making matters, it would have passed through scrutinies post-decision also. Normally, some audit would have pointed out something, or there would have been some complaint, and government would have carried out an administrative investigation. If it has happened, the second aspect that will have to be examined by the government, by the competent authority, before sanctioning previous approval under Section 17 capital A is whether there has been any administrative inquiry into it, and if so, what are the findings of that inquiry? I had recently a case where one joint director of agriculture, certain allegations had been made, and mechanically permission had been granted to the state government to under Section 17 capital A. When I investigated the facts, what I found was that there were 2 inquiries, administrative inquiries. Both of them had concluded that there is no wrong done by this joint director on facts and on the materials available in the files. In such a case, government should take cognizance of the results of its own investigation and say that this is not a fit case to sanction previous approval. Then there is a third category of cases also, or a third aspect to be examined by the sanctioned by the competent authority before granting previous approval. That is, of course, this some people may feel is far-fetched. Some people may find reasoning. Ultimately, this reasoning of me will have to be tested judicially. So far, there is no judicial pronouncement on this aspect. Suppose 10 people have been involved in decision making, and the file discloses that there was no dissent from anybody at any stage, or there was no doubt expressed by anybody at any stage of the decision making. And the choice made by the administrator is one of the choices that was available to him in law. Then a little greater caution will have to be exercised by the sanctioning authority before granting prayer. However, ultimate test in refusing or granting previous approval under Section 17 capital A is whether prima facie there is material to suspect any criminal misconduct on the part of the public servant involved. This test, substance of this test, will evolve over a period of time with the ingenuity of the advocates and acceptance of the arguments or propositions by the judges. Therefore, all of us have a great responsibility in going into background of Section 17 capital A. The harm that would be caused to the individual public servant by a reckless investigation, the prejudice that will be caused to the public interest by preventing an investigation where the materials indicate that investigation may be necessary. All these aspects, I am sure, my advocate fraternity will look into and will propound appropriately. And in another 10 years, we should have sufficient case law on Section 17 capital A. One thing I would like to emphasize, because today the subject is difference between 17 capital A and Section 19. 17A is pre-investigation. Without 17A not by the competent authority, even a preliminary inquiry at the hands of the police cannot commence. Now, who can apply for sanction? Whether it is police alone or complainant can also. In Yashwant Sinha, Constitution Bench judgment of the Yashwant Sinha, that is Yashwant Sinha, the citation is in Yashwant Sinha, that is 2020, volume 2, SCC 338. Supreme Court laid down in 4 or 5 paragraphs 2 propositions. One is previous approval under Section 17 capital A is mandatory. Without that, no investigation or inquiry can be started by the police. Number 2, complainant has to seek and obtain previous approval in case he wants FIR to be registered. Of course, in case he wants to set criminal law in motion. ultimately prayer of Yashwant Sinha, to direct the CBI to register an FIR was rejected by the Supreme Court on the ground that he has not obtained previous sanction, previous approval. However, in passing, they said this does not prevent you approaching the investigating agency and they are obtaining the previous approval. There were previous absence of previous approval is a threshold bar. Naturally, the test that will have to be applied by the sanctioning authority at that stage will be the test normally applied under Section 482 of the Criminal Procedure Code. Then we move on to Section 19, previous sanction, the sanction to prosecute, or sanction for prosecution. Sanction for prosecution comes at a stage where investigation is complete and the sanctioning authority has before him the entire evidence that is collected during investigation. And in some cases, the investigation file would also contain the answers given by the accused government servant or accused public servant to the investigating police. Though normally it cannot form part of the evidence and all that. But the responsible investigating officers, what they do is they examine the accused also during the investigation to ascertain whether he has any plausible explanation against the evidence collected against him by the investigator. This is only at the time of their final mentally making up whether it is a fit case to proceed with the prosecution or not. Therefore, at the time of sanctioning prosecution, the application of mind that is required at the hands of the sanctioning authority is greater and responsibility cast on the sanctioning authority to ensure that a frivolous prosecution is not launched merely based on police story is entirely on the sanctioning authority. But there is a catch in Section 19. First thing is the dispute or the defense of an incompetent sanction has to be raised at the earliest stage of the proceedings. Of course, where your defense is that sanction is without application of mind, then that can be raised only after evidence of the sanctioning authority is recorded, not earlier. But what Section 19 stipulates is that on the ground of absence of sanction or any illegality in sanction, the order of conviction or sentence should not be reversed unless there has been miscarriage of justice. This miscarriage of justice is a very individualistic phrase. I am sorry to say so, but my reading of the various judgments rendered on this aspect of miscarriage of justice gives me an impression that court, while forming its opinion that this illegality in sanction has resulted in a miscarriage of justice, it is the individual mental makeup of the judge concerned that comes into play more often than not. I am not commenting on this as a comment on the judges, but the phrase itself is such that it is like rarest of rare cases. What is rarest of rare cases? There is abundant in a conclusion. What is rarest of rare is an informed view of the judge deciding the case. It is not biased. Like any other says, like it shocks the conscience of the court. Some people's conscience gets shaken easily. Some people are like rock. I am not calling them inhuman. Some of them are like rock in the sense they say that what is this? This is a common day happening. What is they are shocking. Therefore, while protection under section 17 capital A is absolute, under section 19, protection is subject to the condition that it has not caused miscarriage of justice. Then another important aspect about difference between section 17 capital A and section 19 is the extent of application of mind required at the hands of the sanctioning authority. Therefore, stage, there is a difference. One is pre-investigation, another is post-investigation, but pre-trial. Second is the result of absence or inadequacy in that. The result of absence of prior approval under section 17 capital A is that police will have no jurisdiction to investigate. Even if an FIR is filed or a preliminary inquiry report is filed, that would be amenable to challenge if it is not preceded by previous approval. Whereas the consequence of inadequacy in sanction, which unfortunately the Act says inadequacy includes absence of sanction. I don't know what it means. It is subject to the condition that accused will have to establish miscarriage of justice in addition to establishing illegality in the sanction itself. Then third, even if sanction under section 19 is not granted, damage to the reputation and loss of morale in general in public servants, and in particular to that public servant concerned, will be there in section 19 proceedings, even if ultimately the refusal to sanction is there, investigation would have gone on and then sufficient propaganda would have visited the public servant concerned. This new provision, section 17 capital A, I would be happy if at least it gives some courage in the public servants that they can take bold, I'm not saying that uninformed, bold, informed, honest decisions without fear of prosecution or prevention of corruption act for an honest, bona fide decision. And they should not come back to the old psyche that had developed earlier, that best thing for a public servant is not to take any decision. That fear and non-decision arising out of fear, this section 17 capital A is intended to reverse it, intended to make the bureaucracy and public sector enterprises vibrant and competitive and as efficient as we speak of, are generally spoken of, private sector. But I am not one of those who say that private sector is more efficient. According to me, public sector is more efficient because in spite of several wrong policies public sector has still remained intact and it is surviving. It is giving competition. Of course, both corrective actions followed by, again, wrong actions. Everything is going on like we are seeing what is happening in BSNL. Sometimes I get a doubt whether decision makers want the BSNL to survive at all. So in spite of that, the public sector has survived and it is existing. All that is needed is some fillip to take decisions in public sector. I am sure that Section 17 capital A would ensure that some courage is built into the civil public servants to enable them to take decisions. Thank you, Vikas. I think I'll conclude here and then I will take questions. That would be better.
Yes, sir.
Because you were shocked by my short duration or what? No, I have taken, I think.
No, no. It was, as they say in law, that it's my brief, but it runs into 100 pages.
Yes, sorry.
That was all in a lighter vein. Because we all, as a lawyer, say that it's my brief, but eventually it runs into hundreds and thousands of pages.
Yes.
So elucidated, you have explained, and I've seen a lot of police officers and officials have joined this session because they knew that whatever you will be speaking would be an ounce of gold. I've asked Vikram to unmute himself. And I remembered that in a lighter vein, it was said that the wheels of administration sometimes move in a very different manner, where they say that once there is a greasing of everything, it was said that there was an agreement that you will actually do a thing for him. So he said on the file, approved. A person said that why should I grease the palms because it's already approved. So what the officer does is he writes not approved. Now he says that I have to make the payment. What should be done? It is not. It has been written not approved. He goes and greases the palm. Then he says not approved. I'm just checking it out, but it's very surprising that today no one has asked a question. I said Trikram is not there, so we can only pass on. But before we understand, because we have done a lot of sessions on that aspect as to how one should read the files, if there is an interpretation of sections, like after we have also seen the changes in the income tax. Now, what do you mean that whenever we find that how to understand these concepts of, I'm taking this session not with respect to this, once there is a proviso or a note provided, or notwithstanding, what will be the inference for a written proviso and notwithstanding? Does it make a difference?
The word as such, notwithstanding means it gives overriding effect. Proviso means it deals with a specific class of cases covered by the proviso and excludes them the general application of the main provision. For example, say take in the provision itself, provided that no court shall reverse an order of conviction unless the illegality in sanction has caused miscarriage of justice. It qualifies the main provision in its application. Main section 19 says that no court shall take cognizance. It is an absolute ban. Then proviso, it reduces the rigor of the main section 19. Similarly, in seniority rules, you would find where there is change of cadre, at the request of change of cadre can happen either in administrative exigency or in public interest or at the request of the employee. Both can happen. If you see the seniority rule, seniority is normally determined by the length of service in the cadre. That is the main rule. Provided the proviso is that where change of cadre is granted at the request of the employee, he shall be treated as junior to all those who are in the cadre on the date of his transfer. Proviso in such case provides an exception to the main. But notwithstanding anything contained, this non-obstante clause, it can either qualify as to when the protection under main section would be available, or it can provide an exception also, like that, notwithstanding, for example, you have in case of provision for dismissal from service, no major penalty can be imposed unless an inquiry is carried out in accordance with the following provisions. It is mandatory. Then there is one last clause. Notwithstanding contained anything here and above, for imposition of penalty of compulsory retirement on the ground of unauthorized absence exceeding 120 days, no inquiry is required. There, the notwithstanding overrides the main provision and creates an exception to the main provision. Therefore, the interpretation of the proviso and non-obstante clause, it depends on the text, context, and the purpose that it seeks to achieve when you read the provision as a whole in the setting of the entire act or the rule you are considering.
So, can in simple words can we say that it's just like what we say, that the instructions cannot supplant the rules? It is as good as saying that proviso is more or less, that it is not supplanting it.
No. Insofar as a class of cases specified in the proviso, it can virtually erase the rule itself.
So it can supplant.
It can supplant. That is why I said, while interpreting a proviso, you have to read the text, context, and the entire scheme of the act of the or the rules. Remember Chinnapreddy in peerless general insurance case, what Justice Chinnapreddy said. Interpretation is best done if text is understood in the context. Is it a text which is the bone? Context is the blood and life. It has to be read contextually. Like your word may or shall. Depending on the context, shall can mean may. Depending on the context, may can mean shall.
Yes. So, if we have to summarize today's session in 5 minutes, how do you sum it up? Let's assume somebody wants to actually have a summary of that in a bird eye view. How will you summarize it?
I would put it this way. A prior approval at the hands of the competent authority was a long felt need because reckless investigations, reckless launching of cases and prevention of corruption act had incentivized inaction and retarded even dynamic public servants from taking any decisions, because it is safe not to take a decision rather than decide and face the music. That has been done away with, and certain amount of protection is given, and public servants are told that as long as your decisions are bona fide, merely because you take a wrong decision you need not face the music of going through the rigmarole of an investigation and consequent uh, retardation of your career. And Section 17 capital A is mandatory. This is intended to say that ultimately the worth of the fate of a public servant who has taken a bona fide decision cannot be left in the hands of either a complainant who is uninformed or a police who are untrained. Therefore, it is a substantive protection and it is mandatory. But in declining protection, in declining previous sanction, competent authority will have to always remember that public interest demand that no wrongdoing shall go uninvestigated, because it is a threshold bar to investigation. Whereas sanction to prosecute comes at a stage after collection of entire evidence, whether there is a case which is worthy of prosecution. What is worthy of prosecution? We all know in criminal trial, the standard of proof required is proof beyond reasonable. But in my humble view, sanction should not be refused if the entire material before the sanctioning authority makes out a case which is slightly more than or slightly higher than preponderance of probability. Because ultimately, what way the trial ends is too much to anticipate at the time of grant of sanction. It is possible police might have withheld certain crucial material which the defense may bring up. The test is, in such cases, whether a slightly higher proof than preponderance of probability is made out. Whereas at the threshold, when we are examining, the tests are totally different. But both require application of mind, and application of mind differs in extent. While one is the test that is applied by the magistrate or special judge before framing of a charge, other is the test that is set up in Bhajan law for quashing of the FIR. This is my understanding as I am presently advised.
One question is, what about before 2018 happened offences? Is it required Section 17A would be applicable or not?
Which one?
What about the offences which had occurred prior to 2018?
The relevant date for applicability of the 2018 is the date on which you want to commence your investigation. FIR is the relevant. Yeah. And another thing, important thing, Section 19 has also now been amended by this 2018 amendment. Post-retirement also, sanction is required. Same thing in the Section 17A also. Even in respect of a retired public servant, if you want to start an investigation, previous permission.
This is Honorable Speaker says that he is not competent authority and has rejected Section 17A application against an elected representative by stating that he was not appointed by them. They are elected members. What is the recourse?
Investigating police, if he has rejected on the ground of his not being competent, then they can challenge that decision. Because there can always, who is the competent authority for MLA? It is ultimately he can be removed from the membership, if I remember correct, by a warrant issued under the signature of the disqualification of a MLA or member of parliament is something that can happen at the hands of the speaker. Therefore, he would be the competent authority. In fact, about competent authority, under 1947 Act in Abdul Rahman Antil's case, when FIR was filed, he was chief minister. Then matter went to Supreme Court and Supreme Court said, by the time it decided, he had become only an MLA. Under 1947 Act, MLA was not a public servant. The scope of the definition of public servant was enlarged only under the 1988 Act. In the first Abdul Rahman Antil's case, Supreme Court made a very interesting statement. We spent days in search of the sanctioning authority. But now that he has ceased to be a chief minister, it has become irrelevant. And the accumulated wisdom of this court is that it shall not decide academic questions. Therefore, at that time, this question did not arise. MLA, who is the competent authority? Now it will have to be, I think, as the test is like saying, ultimately, under whose warrant the removal occurs, irrespective of the procedure.
Mr. Vikas, you are muted.
Yes.
Yes, sir. So the last question is collection of information and documents of government works barred under Section 17A of Prevention of Corruption Act?
Collection of documents, unless it is something which would fall foul of Official Secrets Act, it is not an offence under Prevention of Corruption Act. Government has a duty to examine the records in its possession while granting previous approval under Section 17 capital, because it is if the object is to avoid vexatious investigations, the person having custody of the documents will have to look into the documents in the minimum.
Thank you, sir. Over to you, Trikram.
Thank you, and my apologies, sir. I was virtually present, but I could not unmute because one advocate from Odisha had come. I had to just log in, and I could not be present here. And as I have missed the wonderful session, but I will make it. I'll make sure that I will listen to the offline video. And I see a lot of participants this time, and especially from the government also, a lot of people have logged in. And they have been truly enriched, because here and there I could hear a lecture, but then after a very long time you have logged in, and you have presented the subject, and wonderful subject, especially for the people who have been practicing on criminal front. This is a wonderful subject, and I missed it, but I will ensure that I will watch the video again. And my apologies for that.
It's not that at all.
Thank you, sir, for sharing your knowledge. And tomorrow's session is on Hindu Minority and Guardianship Act and Section 29 of the Guardian and Wards Act by Mr. S.R. Somashekar, a former principal district judge from Bengaluru. Do join us at 6 p.m. And thank you, sir, for sharing your knowledge. And it was a break from the service matters sessions that we were doing with you.
And I should thank one and all. I should thank Senior Advocate Rajagopal, sir. I should thank Mr. Vikas Chatrat, and I also thank all the participants. Thank you so much.